Hi, union members. My name is Lena Ackerman, and I'm an attorney for NYSET. My job is to protect you, our members, and make sure you know your rights both on and off the job. Today, we're going to be talking about one of the most common but often misunderstood topics, free speech. The terms free speech and academic freedom are used a lot in the field of education and are related, complicated topics that we're going to discuss today. Obviously, free speech and academic freedom both center on speech. But speech may take many forms. It could include oral or written statements, or it could be in the form of symbolic speech, such as clothing, buttons, armbands, or flags. Or it could take the form of campaign contributions or donations to nonprofit organizations. In fact, any expressive act is speech. But whether or not an act is expressive may depend on the context, as well as the content of the action. See, like I said, it's complicated. One of the things that makes our country great is still one of the most argued over and fought over concepts in the Constitution. So here's a quick breakdown. The First Amendment prohibits the government from abridging the freedom of speech, often stated as a right to free speech. But how free, and whose speech? The notion of free speech is often misunderstood as being able to say whatever you want, whenever you want, and wherever you want. It's not that simple. The First Amendment only applies as a protection from government action, and even there, it has limits, especially for public employees like teachers. Outside the employment context, speech made by citizens is generally free, although the government may place reasonable time and place restrictions on it. Before we go any further, I want to make clear that the First Amendment only has implications with respect to government action. So our discussion today focuses on public employees. It does not apply to private sector employers or their employees. A public sector teacher speaking as a private citizen on a public matter has much more freedom of speech than a teacher speaking as a teacher. Because if you're speaking as part of your job duties, you are speaking as a representative of the school, and the school gets to control its own speech. So the first thing we have to do is to ask, whose speech is it? That of a private citizen or of the school? Speaking for the school. When a teacher speaks for the school, their speech generally is not protected by the First Amendment, with limited exceptions, such as those surrounding academic freedom. And as I said, that's a whole separate issue that we'll cover next. But for now, know that when a teacher speaks for the school, the speech is hardly free at all. So ask yourself, if you say something, will you be heard as speaking for the school and in your official capacity as a professional educator? If the answer is yes, or even maybe, before speaking on any potentially controversial matter, make sure you are fully familiar with the official curriculum and the school board policies. If there is no policy, make sure you discuss the matter with your principal or another appropriate administrator. If you believe the policy is misguided or perhaps even unlawful, the way to address it is through political or legal processes, not by speaking contrary to the policy in public, which could result in disciplinary action against you. If you have concerns or questions regarding the policy, before speaking out, you should go to your local union, who may reach out to a NYSET labor relations specialist, or even my office, the Office of General Counsel, for guidance. Speaking on a public matter, a matter of public concern. When a teacher speaks as a private citizen on a matter of public concern, their speech is much more free, but not entirely so. Your speech may be protected, but sometimes it's not. Whether it is or not will depend on the specific facts of the situation. You may not be the only one with speech concerns. How does your speech compare to others who may be involved in the situation? What are the competing interests? In these cases, a court will have to weigh the potentially competing interests of the school district, teachers, students, parents, the general public, as well as the efficient operations of the school. Among all of these interests, any fact showing disruption in the efficiency of school operations would be a factor against the teacher's speech when weighing all of these interests. So when the teacher speaks as a private citizen, not for school, whose concern are they advancing? The public's or their own? And assuming you were speaking as a private citizen on a matter of public concern, how should the competing interests surrounding the speech be weighed? As you may imagine, the answer to this set of questions is rarely clear, and it makes addressing First Amendment issues before they happen very difficult. The First Amendment is as wonderful as it is tricky. So here are some rules of the road to help you. The first category, not protected speech. A teacher's speech made as a teacher on the job, speaking for the school as part of their job duties, is not protected by the First Amendment. In these cases, the teacher is not speaking, the school is speaking. In other words, educators are speaking as employees when their job creates the opportunity to speak. The most basic examples are when one of our members is standing in front of their class teaching a lesson, coaching a team, holding a parent-teacher conference, or driving a school bus. Not protected speech. A teacher's speech as a private citizen about a personal grievance or issue with their school as their employer is not protected by the First Amendment either. For example, an educator complaining that their principal is too strict is likely not protected speech. In fact, in one case, an appellate court upheld the decision of a school district to suspend a teacher who wrote a personal blog that was openly hostile to students, that was open to the public, even though it maintained the anonymity of the teachers and the students at issue. Protected speech, maybe. A teacher's speech as a private citizen, but about a matter of public concern, is protected by the First Amendment, even relative to their public school employer, provided the competing interests surrounding the speech balance in their favor. But we really cannot be sure in advance of how those competing interests would balance. Speaking to the press and writing or emailing letters to the editor is classic protected First Amendment speech, if you make it crystal clear that you're not speaking on behalf of your employer, but rather yourself, and if your speech does not cause material disruption in the classroom. It's not defamatory and doesn't violate someone else's rights, etc. For example, our members often speak out regarding local and national political issues and engage in activities such as attending rallies. Those who do so in a respectful manner in public forums are engaged in protected speech. Again, your greatest protections for advocacy are for speech and activity done off-duty and away from school. This includes things like supporting your political candidate of choice, marching and attending protests, signing petitions on issues you care about, and reaching out to elected officials on issues important to you and your family. When you're expressing these opinions in writing, such as on social media, you may want to be extra careful by including a disclaimer. The opinions and positions expressed are my own and do not necessarily reflect my school district's position, strategies, or opinion. It may seem like overkill, but it can be helpful if you're speaking out on a topic that some may view as controversial. Whenever you can, before speaking out as a private citizen on a matter you believe may be of public concern, especially when it may also be deemed controversial, consider starting with your local union and NYSET labor relations specialist. They can help determine if the concern tends to be more personal or a matter that's more of a public concern. If they determine the matter tends to involve your own personal concerns, perhaps a grievance about your employment, it will likely serve you best to address it through the proper channels rather than going public immediately. This could mean filing a grievance or speaking with administration with union representation. There's one other important thing every NYSET member should know. Your speech may be protected if you are speaking out against discrimination. There are state and federal laws that prohibit discrimination and protect people who are retaliated against by their employers for complaining about the discrimination. A few factors must be present to receive this type of protection, though. First, you must reasonably believe you are reporting illegal discrimination. This means you're not reporting someone merely being treated poorly, but someone you reasonably believe is being treated unfairly based on their race, gender, disability, or some other protected category. You must also be able to connect any adverse action taken against you by your employer to your reporting of that discrimination, which may be difficult to prove. For example, there's a coach who has a good employment record and receives better ratings than other coaches, who was fired a week after complaining about female sports teams receiving less money in the budget than male teams. In this case, the coach may be able to argue retaliation in a lawsuit or in a defense in a disciplinary hearing if they have tenure or due process protections. Our job is to make sure you are protected. If you think something you want to say tends to involve a public concern, but you aren't 100% sure, you should still consult your local president and your NYSET labor relations specialist to be sure. At least they may be able to give you the peace of mind to speak yours in a way that won't lead to potential disciplinary issues for you. They may also help you figure out the best way to present and deliver your argument publicly in a way that's most effective. A reasoned presentation at a school board meeting, writing a well-crafted letter to the editor, or by the union advancing the issue in an organized advocacy campaign or another appropriate political or legal action. At the very least, they can help you present your point of view in a way that's most favorable to you and least likely to result in the school district taking action against you. The First Amendment only has implications with respect to government action. It's not a ticket to say whatever you want, whenever you want. And while we rightly call it free speech, it's not consequence-free speech. Consider how anything you say will be interpreted by those affected. Will you be seen as talking on behalf of the school? Or even if you're speaking as a private citizen, does what you have to say potentially have effects on your school district or how it functions? As a rule of thumb, your greatest protections are for advocacy and speech done off-duty, away from the school. And remember, disrespectful or profane speech is more likely to be disruptive than respectful speech. Courts balance the school district's interest in controlling speech against the educator's interest in free speech to figure out if the speech should be restricted or not. Lastly, your work is vital to our communities. As educators and role models, you may have many opportunities for advocacy, some of which are protected, and others that may not be, and could even lead to discipline. Just remember, your union is here for you. Your local president, NYSET labor relations specialist, and NYSET legal department work to protect you and represent your interests. Don't be afraid to reach out with questions.